staying with us through our last panel. So we've been talking so far about values, what we think intellectual property is for, and how it can be justified or how it might be critiqued on normative grounds. We've talked about what kinds of questions those kinds of normative commitments would lead us to ask, and now we're going to think about how we might answer those questions. So we've got, for this panel, just a really great and diverse lineup of scholars engaging in different and novel methodological approaches to this kind of problem. And we're going to start off with a trio of scholars who have been engaged in a series of investigations through experimental methods of the kinds of questions that we're interested in. So I'll hand it off to you, Chris.
Thank you, Jeremy. Thank you to everyone here at St. John's. This has been a wonderful day so far. I'll try not to make it get it off track. So thank you, and I'm going to start presenting, and then Chris and Jeanne will follow me talking about empirical experimental approaches to IP. We think this is really important, in part because intellectual property law, perhaps more than any other field, is motivated by a set of behavioral assumptions about why people do stuff. Why they create, why they share, why they infringe, and rather than just rely on these untested assumptions, we think people should test them. And so one of the ways that we've been doing this over the years is using various aspects of experimental psychology and experimental social science to understand how people think about certain kinds of legal problems, particularly intellectual property problems. Right? And so we're not going to rehearse all of the benefits and costs of doing experimental research here. I think everyone knows most of this sort of stuff. Right? So what we'd rather do, I think, is illustrate some of our interests in and limitations of experimental approaches by using some examples. Right? So obviously the benefits of experimental approaches involve control and causality. You can control very specifically the setting in which people make decisions, and by controlling the setting, you can ask very specific causal questions about what motivates their behavior. To the extent that there's only one thing different between the treatment and the control variable, when you see differences, you can assign causal roles to the differences between them. Of course, that creates all sorts of issues. Obviously, when you bring people into a lab or you use a digital lab online, you run into problems associated with ecological validity. Are the people who are engaging in the creativity tasks that you're giving them behaving in the way that they behave in the real world? These are difficult problems which we're not going to attempt to solve fully here, right? But are happy to think about the nature of these sorts of problems. One of the things we would like to suggest is that there are better ways of handling many of these validity issues, in part by looking around the university. Right? There are many populations within the university of engineers, of designers, of painters, of creative writers, who we might be able to use as experimental test subjects as a way of supplanting or supplementing the types of people that we're studying in these experiments. There are also lots of other people in the world who are doing stuff and can be manipulated experimentally without being brought into the lab. So Threadless and Topcoder and Valve Game Development are all examples of creative communities that have been subjected to experimental methodologies. As this field has developed, it has increasingly shown attention to psychological mechanism, which is something that we think is important, not just showing differences between between a treatment and a control, but trying to be more specific about the nature of those differences, what in fact caused them. And finally, we'd like to make some claim on behalf of increased efforts towards replication, a standard situation in social psychology, for example, but a norm that is only slowly taking hold in legal empirical methods. To think about this, though, right, to think about how experimental methods can be valuable, I want to use an example, right? The example is, how do parties involved in intellectual property issues think about risk? Right? So risk is an inherent aspect of all sorts of intellectual property decisions, in particular one that Chris and I have been thinking a lot about lately, one that we refer to as the innovate-borrow decision. A kind of central decision in the context of sequential innovation. You're a creator who's entering a field. Your question is, should you license the existing intellectual property in that field, or should you design around it? Right? Those are your two choices. And these are all the questions that enter into it. Right? These are some of them, but not all of them. Right? These are some of them. And you notice that each of them involves substantial degrees of risk. How big is the available innovation space? How easy will it be to invent around the existing uses? right? How valuable are they? How much money will it cost to design around them? If I infringe, how likely is it that I'll be detected in infringing? All of these incorporate substantial amounts of risk. So how will downstream creators evaluate the nature of those risky decisions? Well, if you look at the literature, it's not clear, right? So there are now a series of papers thinking about the ways in which creators might evaluate risk, right? So Jim Gibson says, people are risk averse, creators will be risk averse. I'm really cribbing here, right? These are definitely, right? Right? Andrei Suwicki says, creators are risk seeking, they'll be risk seeking. Steve Horowitz says, it depends. Sometimes yes, sometimes no. Sometimes risk-seeking, sometimes risk-averse. Part of the reason that Steve says this is because the social psychology on risk responses suggests that risk has a lot to do with how risks are framed. Right? So I want to give you an example. Imagine that the government, when you file your tax returns and learn that you're entitled to a $5,000 refund, makes you an offer. Right? The government's having fun, right? It decides to make you an offer, and the offer says either you can get $5,000 or you can play a lottery in which you have even odds of either $11,000 or $0. How many people want the first one? Keep your $5,000. Raise your hands. How many people want to play the lottery? Okay, so you guys are better at maybe pretty about an even split, right? I mean, clearly this is the better probabilistic choice, right? This one has the higher expected value, but many people still prefer this. Okay, how about this? Right? Instead, you owe the government $5,000 and they offer you this. Either you pay them $5,000 or you play a lottery in which you have even odds of paying them $11,000 or paying them $0. Right? This is identical except it's a loss, right? So how many people want to pay $5,000?
How rich am I right now?
You're as rich as you are. You're as rich as you are, so very. Right? So that's right. How many people want to pay $5,000? And how many people now want the other option? Anybody switch between them? Right, so a bunch of people switch, right? So lots of people switch. So, right, people switch between these two differences, right? At least one of the reasons, right, suggested by what Daniel Kahneman and Amos Tversky call prospect theories that frames matter for risk preferences. That people are typically risk averse when faced with a sure gain, right? In the first example, when you're faced with a sure gain, people like the idea of having $5,000. They don't want to risk going away with $0, right? So they take the $5,000, they're risk averse, whereas people are typically risk seeking when faced with a sure loss, right? So in the second one, you're like, well, maybe I don't have to pay anything, right? So that $0 looms really large, right? Not having to pay the government looks awesome, right? So there's this prospect theory difference, which suggests that the way that risks are framed might influence the way risks are responded to. Right? And so we're calling this like prospect theory about prospect theory, right? So this is a kind of attempt to think about the ways in which downstream creators respond to risk, right? So, but it's not clear what the answer is, right? I don't know, we've all talked about this, right? Chris and I and Stefan and others, right? Do creators think I can make X amount of money from my movie for sure if I pay a license, or I can make 2X or 0 if I don't? Right, framing it as a gain, in which we think they might be risk averse with respect to licensing behavior, or is it instead framed as a loss for them? I'll lose Y amount of dollars for my movie if I pay for a license, or I could lose either 2Y or 0 if I don't. And at least from the perspectives of prospect theory, the answers to how creators will evaluate that risk, whether they'll be risk seeking or risk averse or risk neutral, depends. And I don't know the answer. Right? And it doesn't seem like the literature knows the answer. It doesn't seem like there's an opportunity to just say creators are risk-seeking or they're risk-averse or whatever. Right? The only way to find out what the answer is, we think, is to run experimental paradigms that would help us give us some purchase on this question. Other aspects of risk deeply involved in all sorts of IP decisions, right, that are worth knowing about. Are creators and innovators particularly disposed towards risk in one way or another? To what extent are IP risks domain-specific? Are people differently responsive to creativity risks versus financial risks? Are some risks more salient to others? These are all the sorts of problems which casual perusal of the literature won't tell you the answer, but which are fundamental to understanding how to design an effective intellectual property system. So, great. I'll turn it over to Chris now to continue to talk about further projects.
Same time. I think. Yeah. So, hi. Here's another question that you can look through the literature. You don't really get much of an answer. There's a little bit of some glimmering of evidence, but I'll just tell you, forecast it. It's pretty bad evidence. So, and that's about dilution, trademark dilution. Dilution, in this case, by blurring. So there's an empirical proposition at the root of dilution that leads to the legal claim. So here's the empirical proposition. If we have a famous mark, a mark that has strong associations with certain attributes, so Mercedes is a good one, right? What do you think of when you think of Mercedes? Wealth, luxury, sophistication, So these associations could be diminished, they could be effaced if I market something called Mercedes toothpaste. Now, the idea of the empirical proposition is no one's going to be confused between Mercedes automobiles and Mercedes toothpaste. Let's just bracket that there isn't some kind of sponsorship or affiliation confusion. That's not the problem. The problem is that the existence in the world of Mercedes toothpaste does something to our heads that impedes the connection between Mercedes, the trademark, and the attributes, the elements of the goodwill for which the Mercedes trademark stands as a signifier, right? So that's the empirical proposition, and it has, of course, led to a legal claim, right? Dilution by blurring. Now, the problem is there's a rival narrative, right? So here's the rival narrative. It goes something like this. So back in the day, in the 20th century, in the mid-20th century, Cadillac was a prestigious mark. And people started using Cadillac linguistically, the Cadillac of beers, the Cadillac of dogs, the Cadillac of this, the Cadillac of that. Right? Cadillac was like a mark of quality. People started applying it to Cadillac of bicycles, to different kinds of products and services. Does that dilute Cadillac, or does that, in a sense, distill it? By which I mean, whenever we hear Cadillac, we expect quality, right? It reinforces it. It kind of deepens the connection between Cadillac, the signifier, and the quality association for which General Motors has worked so hard to achieve and then destroy. Okay, so these are rival narratives, and the literature at the moment does very little, almost nothing, to tell us which of these narratives, both of which are plausible, neither of which command our assent as a matter of theory, which of these rival narratives is right. So there's a couple of papers, there's one by Jacobi and Morin, and there's one by Pulig et al. And what these papers do is they measure response times. So if I say to you Mercedes and wealth, okay, and I ask, are these two related? It measures how quickly you say yes or no, right? That's essentially these studies. They're a little more complicated than that, but that's essentially what they do. And they measure response time, and then they compare it to a response time of a set of subjects that have been exposed to some diluting stimulus. So I told you Mercedes toothpaste could be a diluting stimulus, and the question is there a significant difference in the response time? Is the response time longer? Does it take longer to respond when you've been exposed to a diluting stimulus? This would permit an inference, I mean, I'm not sure how valuable this inference is, but permit an inference that the connection between Mercedes, the signifier, and wealth, the attribute that Mercedes is supposed to signify, one of them, has been weakened, has been effaced. Both Jacobi and Morin and Pulig find response time differences that are a matter of milliseconds, but that are statistically significant in their survey. Okay, so we wanted to, by we, it's Barton Beebe, Joel Steckel from the Stern School, and I wanted to improve on this. And we started to think, well, how would we design an approach to improve upon this? And the reason I'm going to tell you this is to illustrate a little bit the kind of nested task within a task within a task nature of doing experimental work. Experimental work is a great type of work to do for people who like to work. And maybe this will make it clear. So first you have to pick a domain, right? So what domain do we want to test dilution in? So we thought a lot about this. We finally picked cars. Why did we pick cars? Because it's a high level of familiarity in the population with cars. There's a lot of advertising about cars. Cars have significant associations, right, that manufacturers have worked very hard. And there's a lot of famous marks among cars. So marks that would qualify for dilution protection. Okay, so we pick this domain. And then we start testing for brand attributes. So now we have thousands of subjects that we've recruited online who we randomly present car brands to. Only 5, because we don't want to exhaust them. We say, do you know this one? Do you know this one? And when they identify 5 that they know, we start asking them, well, name the first 5 things that you can think of when you think of car brands, right? So we show the Mercedes, and they say expensive, prestigious, luxury, wealth. They say 5 things or so. So we get all this data back. This is thousands of subjects, tens of thousands of observations, and we start coding the data, meaning, is expensive the same as pricey? Right? Is cheap the same as cruddy? right? Now, you can have debates about this, but we try to code these responses, and then we do, we basically do a histogram, so we try to figure out, what are the top responses? And from this, we can get both a set of characteristics that seem to fit certain car brands, and then we check these against some marketing surveys that have already been done, and there's a high correspondence, but we want to get our own data. We also can tell something about whether a brand is strong or weak. So what do I mean by strong or weak? So Mercedes is very strong. Most people have a pretty tight set of reference that they think of when they think of Mercedes, right? The ones that I mentioned. Infiniti is very weak, right? So when people think of Infiniti, they name a lot of things. The word cloud for Infiniti is very large and diffuse, whereas the word cloud for Mercedes is very tight, and each word is pretty big, it moves pretty large. So that's the difference between a strong brand and a weak brand. Okay, so once we've done that, we pick a strong brand and we pick a weak brand, and the first thing we do is we try to replicate and to some degree improve upon the tests that we already have, the response time tests. And we're doing this now. Let me tell you a little bit about things that we found out. I'll show you a little bit of data. So the first thing we found out is that the existing literature has a gigantic, horrible small n problem. Both the Jacobi-Morin test and the Pullick test have too few subjects in their tests. Jacobi is the polar case. He has 17 subjects in each branch of his test. Now this turns out to be a problem because one of the tasks within a task that we did is before we did this part, we did a little thing after this, which was we just asked people, a few thousand people online, to respond to some questions by matching things, questions that had nothing to do with cars, that were totally random questions. Does this go with this? Does McDonald's go with hamburgers, right? And we measured the variance in response time. Because some people are very quick at answering these questions, some people are not. And unless you have a large enough sample such that the slow bellies are distributed evenly within the conditions, you can get a couple of slow bellies in a condition. This can really skew your results. So when Jacobi has 17 people in a condition, this is a problem. So it turns out you need several hundred people per condition to randomly distribute the amount of variation you get in response time testing. So this was like discovery number one. Oh my God, the existing literature has an N problem, a significant N problem. The significant results that they get for dilution might be the result of a couple of slow bellies in the dilution prong of the test rather than, an actual effect. Okay, so that's a problem. Here's another problem. The Jacobi-Morin and Pullick papers, they measure dilution, properly so called. So does Mercedes toothpaste dilute Mercedes automobiles? What they don't do is put something in the undiluted prong of the test that takes care of what we call I can't say because we're being recorded, the WTF problem. Here's what I mean by the WTF problem. It's possible that in the diluted prong of the test, when you see Mercedes toothpaste, this just causes you to go, WTF, Mercedes toothpaste. And so this changes your disposition and makes you a little bit more cautious about quickly answering matching questions. Okay, so to separate out WTF from actual dilution, in your undiluted prong, you have to put something in like Nike toothpaste. Nike is not properly so-called diluting thing because it isn't targeting Mercedes. It's a WTF thing. It's like Nike toothpaste, which will make you, if there is a WTF effect, it will make you equally kind of cautious about very rapidly answering matching questions. It'll replicate that WTF effect, which I think you have to, this is just an effect of like cognitive load, but not directed at your famous brand. This is an effect actually directed at your famous brand. I think you have to separate those things out. The previous literature never even confronts this, right? So it's possible that they're not even measuring dilution, they're just measuring WTF. All right, so these are decisions you have to come to, and then let me just, after that we're going to test the effect on attributes. So even if response time is an effect, like who cares? I mean, if you're in a purchasing environment and there's an effect of like 50 milliseconds, like do you really care? Does that actually make a difference? Is this the kind of thing we should be regulating? What are we doing next? Are we doing pre-crime? What we want is like a test effect on attributes. Does dilution change your understanding of the attributes of the Mercedes automobile? Or a test effect on overall goodwill. Does it change your appreciation of how good or bad Mercedes is? So those are things we're headed to next. But let me just show you some data. So here's the data from our latest pilot. Our pilots contain a lot more subjects than the Jacobi-Morin or Pullick tests. We don't see dilution, right? So here's Mercedes and Infinity. I'm just reporting on these now. We've never seen dilution for Infinity because Infinity is a very weak brand, and this at least supports the orthodox account that dilution happens to strong brands, not weak ones. People don't think enough about Infinity, don't know enough about Infinity to be diluted. Infinity watches, Infinity toothpaste, yeah, Infinity, you know. On the other hand, Mercedes, which is a very strong brand, occasionally you'll see the glimmer of something. But here's a couple of things. If you look at the differences here between diluted, I'll explain what context is in a minute, and undiluted, that's with the Nike ad. It's just a WTF ad, it's not a diluting ad. The differences are sometimes positive, sometimes negative, but only one time are they significant. This is not strong evidence of dilution. This is incredibly weak evidence of dilution. That context thing is actually kind of funny because when you have no context, there is evidence of dilution with a link between Mercedes and cars. So what do I mean by context? Context means that before we ask you, we show you the ads, we ask you, just write 2 sentences about the last time you rode in a car. Okay, we give them some context of cars. Whatever dilution effect happens when there's no context gets turned off when there is context. And this suggests that in a marketplace, which is usually full of context, if there's a promise of dilution, it might get turned off, at least measured by reaction times, which is a bad measure, but we've got to start somewhere. So there's an example, just for what it's worth, of the crap you have to go through to get an initial set of results, which may or may not be good, because now we've got to run this for real with several thousand subjects, and we'll see what happens. I'm betting that at the end of the day, the reaction time tests for dilution are going to go down the tubes, but, you know, we'll see. Jeanne, you're up.
Please call this paper the WTF effect.
Yeah.
Many S's are
Yeah, F-U-C-K.
Many S's.
Exactly right. Yeah, not quite as it won't get quite as many downloads as the bug paper, but
So I wanted to pick up on the thread and be a little meta about some research I've done with Chris and Chris and some work I'm doing right now. And so first I just wanted to talk about pitfalls in experimental research. I think there are things we know, but I wanted to illustrate them a little bit with examples to give yet more texture to some of the issues you face when you do experimental research in IP. And the first thing I did want to talk about is the care you need to take. So the work I did with Chris and Chris, if you're not familiar with it, was inspired by the difference in creativity thresholds in copyright and patent law about how much creativity or originality you had to put in to qualify for protection. Copyright is very low, patent law is very high, and so we wanted to test to see whether lowering or raising the threshold affects the creativity of works that get created. Okay, and so when we started this, we thought, okay, we need a lot of data, we're going to run this online, and Mechanical Turk is great for doing a lot of this research, but we wanted to see the effect of varying incentives. What's the problem potentially there is that in order to get subjects on Mechanical Turk, you typically have to pay them. They're motivated to participate by money. So not only is there a selection bias issue potentially on that front, that they perhaps look different than the population, but you have to pay them. And so by paying them, you're offering them an incentive that might affect different conditions differentially. And so we had to figure out what to do with that. What do we do? So at first we ran this with giving them no incentive. It took forever to get any data. But when we did, we got interesting and statistically significant data. So we decided, here was the insight, let's run this again, now giving some minimal amount of money and see if we get any different results. So we did that. I can't remember. Do you remember how much it was that we gave them? It was very little. And we got data in like 2 seconds, which was interesting. But 2, we got the same data. It looked the same. So we now knew that this wasn't an incentive that was affecting the conditions differently, and we could proceed. It's just to show that even like these little tiny details are really important to get right when you're doing this, because otherwise the results lose their meaning. And this is stuff that you need to report, and because you have to tell people that this is going on. So that's one illustration. The second thing, and I think Chris outlined this pretty well, is the timeline. that it takes. And I think this is particularly an issue for us in the IP space where there's not a lot of experimental work that's been done. And it means that we don't have a lot of canonical tasks to build on. There are some areas, perhaps in psychology or elsewhere, where lots of people are working in the space, and now there are canonical tasks that people work on, and you refine that when you want to test something a little bit differently. They're asking things that might be relevant to us, but often not exactly on point for the legal questions that we want to get at. And so because of that, you have to spend a lot of time getting the tasks right. Now, I think it's a service to the scholarly population at large that wants to do this further, because then hopefully some of these can become canonical and can be building blocks for other work. But it's we don't have the methodology and the tasks set out yet, so you have to spend a lot of time working on that. So it takes a long time to get to that point, and it doesn't get reflected in the results. So that, it's not apparent from reading the study. The last thing, and this is something that Brett and I have definitely talked about, is you have to have a lot of patience and hold back from making big conclusions. As legal scholars, we're definitely more willing as a population at large than perhaps social scientists are to make big normative conclusions. And I like that generally, that we're willing to go out on somewhat of a limb for what we think might be justifying something, or might be the explanatory method. But it's harder to do that in this context because, again, we're at a very early stage in experimental work. So, can we make big conclusions about the law from the fact that we found differences in the creativity of the works based on the threshold? Probably not. I mean, you could be speculative. Well, how is this going to scale up when people have a lot more time to work on a creative task? How does this scale up when people are working in institutions? We don't know those answers to the same extent, and so it's hard to make big conclusions. I think it's really important to do this work because it's only through doing that hopefully we'll get from A to B to C to D to Z, but you have to be patient to do that. So that's, the three things that I wanted to point out that might not be apparent from undertaking this work that I think is very valuable to do. I wanted to turn to talking a little bit about other empirical research very quickly, and this is work that I've been doing with Barton Beebe. Some of you may have seen me present this, or Barton present this on an empirical study we've been doing about trademark depletion. How much of the English language has been trademarked? How hard is it to get good marks to register? I mean, there are a lot of assumptions built into the literature that there are no costs to granting trademarks for the most part, and that marks can be easy shorthand, but are we running out of those easy shorthands? And so we assembled some data using the USPTO's trademark case files data set, as well as trademark examiner office actions, and we combined that with data on usage of the English language over a period of time. And the reason I want to show this comparatively, I think it allows us to ask more complex questions than we can at this stage about in IP than I think we can do with experiments. So there's something alluring to being able to go to that, but you need the data to do that. Some data is easier to get at than others, but it really is hard to find and assemble the data even in this context. So just to give you one quick example, at some point I spent weeks pulling out which words are disclaimed in trademarks because it's represented in a very poor fashion that requires very sophisticated techniques. Same thing with word marks that are foreign words, figuring out what language they're in and what their translation is in English took a good week or two, and it's still not 100% accurate. So, it's hard to get at. Then once you have this data, you have to figure out what tools to use on it. And so here I'll just give you some sense. We wanted to ask, what proportion of words in English are the subject of trademark registration, and we were able to use that combination of data to get at that and look at that across, different classes of goods and services. How has this changed over time, and how does this vary across different classes of goods and services? Are there more fanciful image and phrase marks registered over time, which we thought would be the case if it's getting harder and harder to use common words or word marks? And what are the distances among marks? Are they getting closer together as we're getting more congestion? And just to give you some quick sense of some of the results, we thought in this case, we talked to lots of statisticians about whether we should be using statistics for this, and the general sense was no, it would be overkill here. You're able to paint a story using enough pieces of data that connect that statistics would just be overkill here. And so we found that, for example, there are a lot of words, the frequently used words being registered as word marks, even more so when you look at words appearing in multiple word marks. So here you have basically 3 words of the top 1,000 words that are not registered at all, although showed and seen. And but just, this gives you a sense. I'm just trying to paint like the different parts of the data that get at the fact that there's depletion. So you see a declining applications for standard English words. You see that mark length is increasing over time. Word count is increasing over time. You're getting more refusals for being confusingly similar, the more the word is common. And the point being that, it's very important when you're doing this sort of work, I guess, to try to figure out what tools you need to use. But you're stuck with the data that you can assemble reliably. But the good thing is that I think by doing these projects that often start with the data that's more readily available, it pushes you to think about how do you assemble the data sets. How can you find data to get at the other things? So for example, just to finish this up, we've been asked a lot about, well, what about company and brand names historically over time? Companies that do better, companies that go under. So we're working on assembling a data set now to look at that. We're assembling ways to test fanciful marks. Are certain desirable phonemes being reserved more than others? Are some fanciful marks really not fanciful? Can we distinguish between those? The last thing I'll just conclude on is just a little thing I just tested the other day out of curiosity, is one of the issues when you've got data and you're trying to tease it apart, and this is the thing that's the downside of doing this type of research compared with experimental research, it can be very hard to figure out what's driving what. And so one of the things we've encountered as we've been doing this is that, well, maybe there are trends in naming and branding that are driven by constraints. So maybe people turn to fanciful marks because they can't get common words. Maybe they turn to fanciful marks because all of a sudden it's cool for some other reason, and it's very hard to tease that apart. And so one of the things that I'd seen an article recently that there's been this trend for noun and noun naming. So I thought, well, that sounds like it could be driven by constraints. You can't get a word, so you do word and word as a way to get over that hurdle. Or is it a trend on its own? And in fact, I was like, oh, I could look. We have the data. Let's look how many words follow this pattern. And you are seeing increasing filings and publications of marks that have this, but we still don't know. And so you either have to get more texture, we've been talking to branding experts on this to get a sense of what's driving these trends. But the bottom line is that there are limitations, and it's only by putting all these different empirical pieces together, including the ones that we're going to hear about, that I think we're going to get a better picture of what's going on with regard to these big intellectual property questions. Thank you.
Yes. Yes.
I almost stood up for slap on page 12.
Yeah. So, no slide.
Thank you, everybody, for what I think is, as I said, to me, is one of the highlights of the spring. I think we have to do more and more works on methodology. I'm currently heading a Center for Applied Research in Singapore, and what we're trying actually to do is to understand what is applied research in intellectual property, and we do want to do more work on methodologies. I'm going to talk about comparative legal analysis, and I'm very grateful to Jeremy and to you all to giving the opportunity to a US/ non-only US scholar to talk to a US audience about comparative legal analysis. I grew up with comparative legal analysis. I took as part of my core curriculum in law school, comparative law, international public law, international private law, multiple comparative classes as part of masters. And that's certainly not the case in the United States. The goal of this short contribution to the symposium is trying to, first of all, seeing why in the United States we do less comparative legal analysis. Myself and others who do international IP are very used to be slotted at the last day, the third panel, WIPIP or IPLC, when there is, something doesn't really fall with another, there is some international, okay, let's stick it all together, rather than, put a comparative paper on copyright in the copyright track, or a comparative paper on trademarks on the trademark tracks. We have, our own little ghetto in some ways, and that's true. It's an empirical analysis. We can go back to many years of programs, and we can see that. Not pun intended. That's why also many of us do both national, core national analysis and also comparative legal analysis. I started to look into this issue for a ATRIC conference in 2012 in Chicago. Graham Dinwiddie has edited a book that is really a good book on method and perspective in intellectual property. And looking at comparative legal analysis in general, and I give you the chapter I wrote in that instance, the first things I argue is that I think in intellectual property law, comparative legal analysis is better than in other fields. That's by necessity. Most in law school do teach international IP because our students need to know what's the Paris Convention, what the Berne Convention, but even most importantly, what filing patent to the PCT or filing trademark application to the Madrid Protocol is, whether they have a small practice or they work on a bigger practice. The necessity of trade and everyday practice really imposes us to teach them these issues. However, I also started to ask more question to myself is, what is comparative legal analysis? Because for me it's always been something intuitive, you grew up with it, in Europe you have to do it, and how should it be done in intellectual property? And the more I start digging into the methodology of comparative legal analysis, the more I found that the purest of comparative methodology, first of all, is unclear if comparative law is a field or is a method. I would say it's more a method than its own core field, because there is really no statute, there is really no cases, just on comparative law. It's more always a comparative analysis of two jurisdictions, pieces of two jurisdictions, and so forth. But I start to see that the transaction cost of doing comparative analysis at the purist level are very high, because the idea is you need to know about comparing, you need to know about the sources and the language. Ideally, you have to spend time in the different countries and so forth. And my approach has always been, you want to keep this transaction cost as low as possible, because you want to make people know more about comparative, because that's very useful. And once they know more, or a little bit more, they will be more enticed to do more and better and better. First, you start with an interest, then you start with a trip, and then you start with a stay, and so forth. Jeremy is going to spend 6 weeks in Japan this year. Many of you do like, to spend, time abroad, and many of you have come to Singapore, and hopefully more of you will come. And so my first conclusion is that we do need to keep the transaction costs low, because we want people to do international and comparative analysis, primarily comparative analysis. We don't want to impose reading in French or German or Chinese, because otherwise very few scholars will be able to do it. However, you want to pave the way for more of these interactions, so then collaborations and co-authorship can be done, for example. But I also think for us as US scholar, I don't know how many of you took comparative law, just by pulling the hand, not many. How many of you have taken international private law? Not many. And that's something that if we are used as students to do, of course we're going to do more. And always any question we ask, we just don't put in a national context, but immediately put it in an international context. We look at the supranational level, we look at the comparative level. That not because we always have to make a comparison, but just because we can contextualize things better. When we think about incentive, for example, in the United States for inventions, we think about patent. The same question are not in the same context in India, or not in the same context in Cambodia, or not in the same context in China, or not even in Germany. Some level of economic development are the same, and some country needs may be the same, but historically, and even a contemporary contextualized analysis, a lot of questions might be different. Then we just gather more information through having the comparison made, and then we can decide that we don't need or we don't want, or for that specific reason we want to focus on national or even a statewide analysis. But we know that there's more out there that we either already know about or we could know about that we can learn from. Martha Mino, the Dean of Harvard, wrote a very beautiful piece with some very powerful sentences in a recent issue of the Harvard Journal of International Law. And really, she's an international law scholar, and she points out that it's really missing the opportunity to learn more. And that's why I think as US scholar, if we do a little bit more of it, it's something that we can all benefit from. I think today, we cannot escape the consideration that that national intellectual property is heavily informed by international agreements. I'm sometimes reading scholar pieces about likelihood of confusion, trademarks, and so forth. We know one word, such as Paris Convention or TRIPS agreement, just even dropping a footnote about. And I always am puzzled because it's really important to know some of the framework. We might disagree with it, but it's always very important. We talk about fair use a lot. It's always important to know the three-step test in the Berne Convention, and of course in the TRIPS agreement, because again, it's contextualized. We need to know about the dispute settlement at the WTO level. We need to know about what is in the TPP. And I'm sure everybody here knows the 12-country member of the TPP, but I can tell you that a lot of people talk TPP, but if I ask them, sorry, what country are a member of the TPP, they cannot really list them. And so there is a lot of discussion often that I feel is not very well informed. And again, it's in our own benefit to do that. Anne Bartow and I were talking last week, and she pointed out something that I also agree very much with. This often comparative legal analysis is done very poorly because people don't know well enough. But keep in mind, often is foreign scholars who try to do comparative analysis with the US. It's commendable that they even try. You start with something not done very well, and you can perfection it and make it better and better. But again, it's really the methodology can teach us about. I see the value methods and question as a circle, and it's a movement. It's a circle that moves. We have values that can be normative, can be different type of value, and I actually agree with Professor Mergers, and I also agree with Professor Lemley in their approaches. Because I think they're actually very compatible. I think there are different methodologies. Empirical studies can look at empirical study in jurisdiction A, jurisdiction B, historical changes within the same jurisdiction. And then different regulatory approaches in different countries. Think about access to pharmaceutical, the way India deals with it, with a much tighter approach of non-obviousness, the compulsory licensing approach that some other countries have adopted, Thailand, Indonesia, and so forth. We might agree or disagree with the fact that Canada invalidates illegally patent, but yet again, that's another way to deal with the issues of pricing and access. The actual way we might deal with issues in the United States. To know more through comparative analysis is always very useful. And I'm trying really to make a pitch that we as US scholars should do more about it and should integrate it in every, I hope next WIPIP can actually be. I think this year was already much more integrated. CARIS has a long tradition of international and comparative exposure. We should integrate it. And what we don't know well, we can learn more, and others know more our law because they come here, they study, they do LLM, and they go back. And our community is probably the best community, I would say, in the whole academia in IP, and I know many different academias. But I think keeping the transaction cost low, looking at the different issues in different countries. For example, Fumi is doing very interesting work in Africa, has done, will continue to do in Europe and in Asia. it's always very useful because we can understand better what happens in our own jurisdiction. And sometimes I come back to the US and I say, I think we have a great system, much better than others in certain issues, where we can learn other elements, for example. And so methodologically, the comparative method is very flexible. It can be from just a pure description to a much more in-depth analysis using comparative empirical, comparative critical, for example, critical studies. I've done work in diversity, in critical race theory and critical gender theories under multiple lenses in different jurisdictions. It's very different, for example, the cultural differences in cultural studies. And I think it's of course always fun to travel, but it's really, as you know, I fully agree with what Jeanne said before. Big conclusion require patience, but they're often rare, and this should not be the goal. The goal is really gather more information that can get small conclusion, but pointed with the understanding and this conclusion are always in action, and they can change over time. And what is really useful is to have the methodology set. And thank you very much.
Okay, so we've got, now, everyone wears a number of methodological hats, actually. Frischmann from Cardozo is going to talk to us about a few of the different approaches that he's taken in his work in collaboration with us.
All right. Thanks, Jeremy. Thanks, Ava. Thanks, St. John's in general. It's been a great conference. I got a lot to say in about, what, like 15, 20 minutes. I got to hurry. I'm joking. So I'm going to talk to you about two projects, in a sense. So I'm going to just talk quickly. One is early stage work in progress. They're both research agenda, methodological sort of research agenda type projects. One is at the early stages with Mark McKenna. It's about comparative institutional analysis, analysis of innovation institutions as well as failures and context. And then the second, and that's early stage, tons of work to do, and I'm inviting people to join the party. Knowledge Common Studies is a project I've been doing for over the last 10 years with Kathy Strandberg and Mike Madison. We anticipate doing it over the next 10 or 15 or 20 years. Patience is the way you learn. I'm more interested in doing social scientific studies of the sorts of things we're interested in. And so I'll talk to you a bit about that real quick. All right, so I'll start with the comparative institutional paper. Basically, Mark and I think that in the next 10 years, there's tons of medium-hanging fruit on this IP scholarship tree for those interested and willing to do comparative institutional analysis. It's not low-hanging. It will take building scaffolds and ladders to get up there, drawing from social science, other social science disciplines, such as institutional economics, sociology, and political science, among others. But we identify a couple of shortcomings in existing comparative institutional papers, including, so we're not critical of any particular paper. We ourselves have had the same shortcomings in our prior work. My first article I ever wrote was about comparative institutional analysis and analyzing patents, tax incentives, grant system, and procurement as alternative ways to achieve innovation in different sectors. And I also suffered from some of these problems as well. The point is really, again, looking forward how to do comparative institutional analysis better. So the thing is, comparative institutional analysis requires a basis for comparison, right? So the first problem has to do with persistent ambiguity in IP scholarship about what our normative baselines are, but the basis for evaluation. And then the second one, comparative institutional analysis requires analysis of failures as well, which, and I'll say a bit more about that real quickly in a second. On normative baselines, analysts often attempt to compare institutions in terms of their effectiveness achieving some end, but too often the end is taken for granted, left unspecified, or if it is stated, it's stated so generically that it's devoid of meaning. So in the paper we discuss a bunch of examples. You might think progress in the science and useful arts, innovation, meaningless, optimality, meaningless when you're talking about evaluating IP, or doing comparative analysis of different institutions standing alone. So we list a bunch of different objectives, all of which I think are perfectly reasonable interpretations, both from a legal standpoint as well as a functional or a normative standpoint as to what we might think progress in science and useful arts might mean. Just as an example, we could also use innovation or use something else to talk about what we're trying to optimize. in IP. Now these different objectives certainly may seem like different shades of gray, but the variations matter quite a bit in terms of institutional design and ultimately in terms of comparative institutional analysis. I think legal scholars have an odd relationship with normativity. Sometimes we're really committed to saying something normative. Every legal workshop ends with, well, what's your normative punchline? But at the same time, we're kind of afraid to actually engage in rigorous normative debates about what it is that we're seeking to achieve. We just state it and move on. But I think, well, Mark and I think legal scholars are actually incredibly well suited to be doing institutional design and comparative institutional analysis along with political scientists and others from other disciplines that I mentioned before. It is, after all, what we teach and do as lawyers, right? We design institutions, whether in contract or property or other things or other organizational arrangements. But I think to do so as scholars, at least, we need to confront and be much more clear about what our normative baseline is. So we propose, and these are completely tentative, we propose a couple of tentative approaches to dealing with the seeming intractability of normative baselines. We appeal to comparative analysis within and then across scenarios where a particular scenario might correspond to a particular normative objective. So you can imagine holding economic growth, or we might say maximum participation in cultural production, as the relevant end. Hold that constant and do comparative institutional analysis in a particular study to see how well it actually performs, what combination of patents, trade secrecy, what different variations in terms of institutional design might work. And then if you did a meta-study across the various studies, you might actually learn something. You might find out that the set of institutions or designs that work best, second or third best in terms of across normative objectives, happens to turn out to be no patents and really strong trade secrecy, or vice versa. I have no idea what we would learn because we don't do these kinds of studies, but we might learn something if we did. This obviously takes a lot of work. This is not something Mark and I can do alone, and so that's why we're sort of making a pitch. Just theoretically, this is one way you might be able to do the work and do it well. The other point we make about scenario analysis is we consider the advantages and disadvantages of comparative institutional analysis at different levels of micro, meso, and macro context and specificity. Legal scholars tend to operate at the meso level, talk about reforms to copyright and patent affect the national system, but I think we would learn a whole lot more if we focused on meso, sector-specific levels of context as well as micro-level context as well. When you move from micro to meso to macro analysis, you're losing something, which is you're losing relevance and connectedness to real-world systems. You're also diluting information about what people need, want, and demand in various contexts. From a purely normative perspective, focusing on the well-defined and politically acceptable objective that serves as a basis for comparing institutions, assuming we've done that work, the more micro you go, the more trustworthy the analysis will be, it seems. Right? We can actually identify, when we see economic growth, or one of the other things I listed before at the macro level, it's completely contestable. It's just a choice that the author has made. On the other hand, I think we can reach more agreed upon politically acceptable normative commitments if we think what is it within a particular sector that people in that sector, both on both sides of a market, for example, see as the goal of that sector. Or in a more micro level context, we might think solving malaria, like what are the relative health related innovations we might want to focus on developing to solve malaria. That's a politically acceptable, readily identifiable normative objectives for which we can do comparative institutional analysis. Of course, the more micro you go, the more open you are to being challenged on the specific objective. Why malaria rather than something else? You also might be challenged on whether generalization is possible, and you also might be challenged on whether prescription for legal reform can actually be adopted, especially since we tend to do that at the national level. And so there are trade-offs as you move through these different approaches to dealing with the problem. But nonetheless, I think it might be important to do. The second set of points we make in the article have to do with comparative failure analysis. Our argument is that to do comparative institutional analysis, you have to think about comparative failure analysis as well. I'm going to skip explaining why. That's in the paper. I'll try to just say real quickly about how, or at least some of the ways we're thinking about it. We start with a preliminary diagnosis of failures and develop the distinction between system-independent and system-dependent failures. So some obstacles to achieving our stated objectives or ends or goals are a function of variables, characteristics, or circumstances that do not depend on the provisioning system. right? So we call these system-independent failures. They occur across all systems and aren't a product of the system. In a sense, they're a function of the resource environment and or of human nature. So a few examples that we consider. Short-sightedness is an example of a characteristic of human decision-making in human beings. Non-rivalry is an example of a resource characteristic. We could come up with others. Externalities are an example that can be a combination of the two, both resource environment and human decision-making. But the main idea is that the dilemmas associated with all three and other examples we might think of as system-independent is that they trouble markets, governments, and communities or commons. Perhaps in different ways, perhaps one or another of the systems is comparatively better suited to dealing with the dilemmas than others, but that needs to be shown rather than assumed. Okay, and so I think there's a lot of work to do spelling this out. The second distinction we make is system-dependent failures. Market failures, political system failures, community system failures describe failures that occur within the system and are a product of the system. They derive from society's decision to use a particular system as the provision, to provide or meet our wants and needs. So I've read a lot already about market failures that arise on the demand side, which is the problems of relying on the price mechanism to figure out that which we want. So we can think of these as demand manifestation problems. But we can think about others that arise in political contexts, and we can think about others that arise in the commons context. So the bottom line here is that there's tons of work to be done. We start to think about some applications. I think climate change would be a really interesting one to follow through on. We haven't done it yet. But the idea is that there are at least some readily identifiable, politically acceptable objectives that are technology related or innovation related, and they're distinct. And we might do some comparative work and institutional analysis work to figure out how best to promote and achieve what we're looking for. How much time? 2 or 3. All right, knowledge condensation. I'll do this quick. There's a book, we've been working on this for a decade. There's a bunch of articles. We've got a book that came out in Oxford 2 years ago, or I guess, 2 years ago. Another book coming out later this year on governing medical research commons. And we just reached an agreement with Cambridge to do a book series, meaning we can do singly authored monographs as well as collections of case studies and other things that are applying the framework I'm going to show you in a second. So we're kind of building a field where we can gather research and have an outlet for it to be done. I won't go over the motivations. These are pretty standard. IP theory is overly simplistic. It doesn't make a whole lot of sense. We all know that. I'll move on. Commons work. There are some one-off case studies where people talk about community-based production, open systems, etc., but they tend to not ask the same sets of questions, so it's impossible to generalize. You take all the Wikipedia, patent pool, take all these things together and put them on a table and try to see if you can generalize common variables, ask all different questions. You can never generalize from them. So we've spent a lot of time trying to figure out how to systematize the inquiry. We turned to Eleanor Ostrom's work. She won the Nobel Prize in Economics. She passed away recently. She's a political scientist. She studied environmental commons, community-based management of natural and environmental resources. She developed this institutional analysis development framework to do structured case study, qualitative-based case study work, but also experiments and quantitative work grew out of this as well. It doesn't just deal with fisheries and agriculture and environmental, we can use it to explore soccer leagues and other things too. Design principles lead to the Nobel Prize. We think we might find design principles for knowledge commons over time, but it's going to take a decade, it's going to take patience and lots of work. The resources are different, the community issues are different. We adjusted the framework. Here are a set of questions we ask of each case study. Don't worry about the content of the slide, read the book if you're interested, but there's too much text. But the idea is to note the structure and the approach. Common sets of questions, variables, and so on to shape the interviews, doc review, analysis of data, and so on. This is to help each individual study be comprehensive and systematic about what it does, but it's also about enabling comparative analysis and learning across a variety of different studies, so we might actually be able to aggregate and learn something. First book has stuff from astronomical data, gene data, open source software. It sort of demonstrates the use of the framework to do this kind of work. I did with Kathy, we worked on a urea cycle disorder consortium studying how rare disease researchers do their work. We're doing another one of those, the mitochondrial disease consortium. We're finding some differences and some similarities in an interesting way about the institutions that are bottom up and work to solve their problems. I'll end with this. Themes from the first round of case studies. These are not theoretical lessons. These are not truths. These are just common themes that were drawn out from a series of case studies. We might learn to develop hypotheses from these. Diverse obstacles and social dilemmas. Free rider exists, but it's not the only problem that these groups face. Nested systems, informal governance, and shared infrastructure are sort of common observations across all of the case studies. Many mixed motivation, it's very complex. It's not always just self-interested, maximize my own welfare kind of behavior. There's often other things going on that motivate people to participate in rare disease, for my case, rare disease research, for example. There's a lot more I could say, but I will stop.
All right, so our last speaker for today is Jessica Silbey, who I am going to, sorry, you have no slide deck? Okay, right. So, who I'm going to offend by reducing her to that one sentence characterization, right? Who is well known these days for a very important book that is published on
which can be reduced to one sentence.
on qualitative empirical methods.
Join the happy crowd. Okay. So we're at the end of the day, and I've got a lot of nerdy notes about qualitative analysis, which I hesitate to just throw away at this point. But what I should say is, first, what I'm about to say is not my original research. I'm just going to be repeating what qualitative studies. That is, I'm repeating the theories of Daniel Little, of Mary Anderson, of Miles Huberman, Joseph Maxwell. These are all famous qualitative sociologists and methods scholars. So this is not a paper. This is a little bit of a lecture of their work. The second thing I will say is that, that's because Jeremy asked me to talk about qualitative methods, so that's what I'm going to do. The second thing is what qualitative methods, there are three basic kinds of qualitative methods, and I'll talk about what those three are, but their major interventions are, one, that they reject causal analysis as the primary mechanism to be studying. That is, cause is not the thing that qualitative researchers care all that much about, and that might sound strange to lawyers, but that's true. And the second thing that qualitative researchers care more about than anything is organizations and structures, systems, rather than individuals. So the unit of measurement is rarely the individual to aggregate an aggregate effect. It is trying to study relationships between parts of a system and understand processes and organizations. So it's not about cause and it's not about individuals, which makes the study of law a little bit foreign in many ways. This means that one of the hard things to do in qualitative work is to separate out the concept of cause from explanation. That is, we're going to try to explain something without talking about causality. That feels foreign, I think, to many lawyers and legal scholars, but that is what most people in social science does. And so I'm going to spend the next couple minutes trying to explain how the different ways they do that. But let me first just give an example. So if I wanted to study, for example, how law professors do their work, optimally do their work, what makes them happy in their work or unhappy in their work, for example, I might send around a survey that asks them how much time do they spend preparing for class, is there adequate time for their research and writing, for example? Are they on too many committees, less committees? And you could ask a series of questions like that, and then there could be like a 1 to 5 scale where they say 1 is not enough time, 5 is the most amount of time, or least happy, most happy. So you send around a survey and collect a bunch of data. But if I sat down and did face-to-face interviews with 25, 30 faculty member and started asking these questions with follow-up questions and started listening to their stories, for example, about what it's like to be a law professor, and they started giving me specific details about particular happy moments or sad moments or things that were frustrating or not so frustrating, I might hear a lot of different things in those interviews that I might want more explanation about, that the survey instrument, for example, would not explain in any real way. That is, the variables that the survey instrument or the data points that we've been seeing all day are, in isolation, aren't very meaningful without the account that is provided by the interview and the follow-up questions that are provided in the narrative explanation by the subjects themselves. So qualitative work starts with those accounts and those explanations of happiness or work or whatever it is, and then from that builds a more systemic explanation of what makes a law professor excellent at what they do from their own perspective, for example, or within the system of a law school and what law schools are trying to achieve. So it is a fundamental shift in how we understand the knowledge that is being produced. It's not cause, it's explanation. So there are 3 basic ways that qualitative work proceeds. One is ethnographic, one is historiographic, and one is through a case method. Those are 3 primary ways that qualitative researchers do their job. So ethnography, I think most people, I think Lily has, no, Lily's right here. As an anthropologist, she knows all about this. Ethnography produces semantic explanations. That is the meaning of a life and a culture embedded in a space. So for example, an ethnographic study of the quilting bees in South Carolina, for example, would provide an explanation of why and how these folks do what they do. It would tell us enough about the culture and social life that we, as outsiders, could understand the how and why of their practices. That it's a form of translation of other practices in our own terms. That's what ethnography does. It is an account of other people that we can understand. It's a translation. It's a semantic explanation. Historical narratives, which is historiography, is a qualitative form of social science. It exemplifies not a semantic approach, but a syntactic approach. That is, it's a narrative explanation of a process of evolution over time, and it builds a reasonable story, and reasonable stories, that is, accounts of explanations of why things happened, why the French Revolution happened, why the American Revolution happened, or for example, follows a sequence of events that leads to a conclusion that we are all persuaded by, and this is really about narrative persuasion, most of the time embedded in facts that can be verified. These operate at different levels of abstraction. Ethnography is generally static. That is, it situates a period of time, and it's not generalizable, usually beyond those time and space. Historical narration is much more evolutionary, and people think that historical analysis gives way to more formal modeling. Standard cause analysis, what we spend a lot of time talking about, does IP cause more innovation, for example, has taken over these other kinds of qualitative explanations, but of course, they're necessary to all causal explanations. For example, if we say that productivity are caused by the presence of copyright or patents, their enforceability, the moral status of piracy, for example, these words, copyright, piracy, enforceability, have no meaning outside, they don't have any meaning independently, right? They only exist as properties of a social system. Piracy, you have to understand what does piracy actually mean in order to be measuring it. They have to be justified. These terms, copyright, piracy, enforceability, have to be justified by a further semantic reference, the meaning of it, for example, embedded in a syntactic story about how people behave. So they all work together. Each method will privilege different aspects of analysis over the others. And it's sort of like a rock, paper, scissors game, actually. People talk about these kind of analyses that way. Causal analysis will trump ethnography, because causal analysis enables generalization and ethnography doesn't. History will trump causation by historicizing its categories, but ethnography will trump history by undercutting the very idea of historical continuity. Each of these trumps involve a move to a different dimension of difference between the methods. And it's not unlike the division in other areas of knowledge production. Physics, for example, biologists are not quantum mechanics, electrical engineers are not biologists or theoretical chemists. There's a division of labor in the sciences, and there's a division of labor in the social sciences as well. And so these different methods operate at different levels as a division of labor, trying to get at different forms of explanation of human behavior. So the last method, which is the method that I'm sure Jeremy wanted me to talk about because it's the method from my book, is the case method. So there are 2 different kinds of case methods, and we sort of heard a little bit about comparative cases and comparative institutions already. So I'll just focus on the variable-oriented case method. So what that means is that you take a set of, it's a generalization, it's a theorization about the relationship between certain variables. So you identify a number of cases, for example, in which phenomena like movie making or biotech investments occurs in various degrees of quantity or type, and then you attempt to isolate the relevant variables to then explain them and put them in a broader context about their relationship, the material structure, and their variations. So what do I mean by that? So for example, if I was going to study what is the role of intellectual property in creative or innovative practices, hypothetically, I might say, what are the relevant variables that I think exist in creative and innovative practices? I would think about all the different kinds of copyright, all the different kinds of intellectual property. I would think about all the different kinds of actors, employees or employers, firms, solos, for example. I would think about whether you're a creator in the first instance or whether you're a distributor, for example. I might think about whether you're a business person or a lawyer or you're a creator. I might think about all the different relevant variables that might exist that we would think are relevant to figuring out whether intellectual property acts as a meaningful lever. And then you go out and you select cases based on those variables. So you find a person who owns copyright, who is a sculptor, for example, who sells her stuff in galleries and has been a professional sculptor all her life. Or you find a lawyer who works in the IP field, who works for a law firm. You select upon all those different variables. And then you collect the data, the qualitative data. You do the interviews, you code the interviews, and then you figure out, you draw hypotheses about the relationships between the different categories of people and systems, material systems in which they are embedded. And then you test those theories about the relationships between, does it matter if you are a copyright holder, if you're a distributor of copyright or a copyright holder, for whether or not you exercise your copyrights, for example, in particular areas or not. And you test those among counterfactuals, they're called, or you then run big number studies. Then you have a theory about the relationships of the variables, and then you take that theory, and then you select, then you use the survey and you ask the questions based on the variables that you've identified qualitatively, and you run large number studies to figure out whether they distribute accurately or the way you've predicted in that study. And so validity in qualitative analysis rests on descriptive accuracy. That is, do people see what you see, for example? Your interpretive validity, that is, when you are interpreting what somebody is saying about creative work, would the person who told you that agree with your interpretation? That's interpretive validity. There's also theoretical validity, that is, whether the theory that's come out of your qualitative analysis resonates with the theoretical literature that exists out there, other literature, for example. And then there's the generalizability validity, which requires these larger studies, the complementarity of quantitative work with qualitative work. I see my time is up. I'll just say that I think the benefits of qualitative analysis are that it allows us to measure variables in combination rather than just one-off. That is, it's not about cause, it's about relationships. And it requires teamwork, which it's hard to do qualitative work without many, many people. And I think this kind of research is best done in teams, in groups, in order for the validity to be measured, to be appreciated.
I'd like to invite all our panelists from the third panel up here, largely to get a picture of all of you, guys, but also because we are at time, and I want to make sure that anybody who needs to leave for the holiday or to catch a flight knows that your cars are waiting. But to the extent that we can sit for just a couple of minutes to get all these people who have just given us a lot of insight into very, very different ways of approaching the problem of creating knowledge about intellectual property. To kind of engage with each other, just for a minute, please. Chris, I think this is you. Have a seat. It's okay. Yeah, you get it. Yeah, you get it. You're going to be in the trial and everybody else. And just, if there's anybody who wants to, has a question that they think can be quickly put to the panel and maybe batted about for just a moment, I'm happy to hear it. Otherwise, I might try one myself.
I have a quick question.
Yes.
If I could just ask Chris this, I think the process you're doing is really worthwhile. I'm glad to hear more about it in progress today. And I know you, Phil, and Martin are not stereotypical males. They're far from it, but as a domain. I'm wondering if you're testing for gender differences and you consider picking another domain, because I quite worry that what you find might be difference over gender and you might not have the best domain. Neutral domain.
So we're breaking out data by gender. We're not seeing any differences yet in terms of either the identification of attributes or the response times. But it's a fair comment. And we have another domain that we're thinking about, which is chewing gum. And the reason, well, I mean, it makes perfect sense because if you think how people buy cars, they actually usually take some care. Whereas when people buy chewing gum, they take virtually no care at all. And so we want to try to figure out if there's a difference in people's reaction to like reading stimuli from famous chewing gum brands and their relationship with these car brands. So I don't think chewing gum is gendered, although I don't know.
So the last thing that I ask is whether we come away from this panel in particular with a bigger appetite for consuming work within methodological traditions that are dissimilar to the ones that we ourselves work in, right? So one of the things that I find is, when I'm working on a theoretical piece, I'm reading lots of philosophy, and every once in a while an empirical paper comes across my desk and is refreshing and helps me to think about the theoretical issues that I'm working on in a different way. And I wonder whether any of the talks that we've seen today or this afternoon create that kind of a spark for anybody in how it informs the work that they intend to do going forward. So anybody want to take just reflect on that?
Just makes me sad that I don't think I could develop the competencies to do all the things I want to do, right? And then just listening to Jessica's talk, it's clear that there are a billion things people should be doing, many of which I'd like to spend my life on. And I'm anxious, right? Taking on one of these projects, just even in the smallest first instance, would be a commitment of multiple years, it seems like.
So then,
it could go terribly bad.
But one of the things that's wonderfully fun about it is that we were at the NYU Empirical Conference just like a year ago in November, and there was everyone was looking at a specific kind of piracy, like there was copyright piracy, whether it's music, whatever, from different perspectives. So Petra Moser was looking at it from a historical perspective, and then there was Joel Waldvogel was looking at it from much more of a quantitative measure. Like you can actually study the same phenomenon from lots of different methods as a team, and that is what I think science is supposed to be.
Yeah, and I think if I could push that further, I think one of the things that we ought to be doing is if you're interested in working in an area, to be gathering the people together who've done things in related areas and have a conversation together to see how you could all further the same research questions using the different tools that you have. I hope that's something that we'll continue to do more of as a community.
There's one thing about that conference that I want to and also about this conference is this Catholicism with respect to methodology, which I think is an incredibly healthy part of the legal academy. So Jessica's explanation of the value of narrative is something that I completely buy, and I think there's a number of reasons to buy it. But one reason is if you're interested in doing narrower causal related tests, you need some narrative that is much more textured so that you have some clue that the thing you're doing is not completely crap, right? It has to fit with some broader narrative, or you should be worried.
Yeah, it has to resonate with lived experience, or I think the validity of the research just gets lost on people. Right?
So what can we then do, since we're taking on responsibility for producing knowledge in this field? What can we do to ensure that those kinds of conversations are happening? I mean, one of the things we do, I can host a conference like this, but I honestly don't have it in me to do this more than once a year.
We can build laboratories. We can have social science laboratories. The way most in social science departments, you have graduate students, which law students are not trained with, but we are all parts of universities where we could have social science lab, like ongoing funded research on these topics.
It's just something either genuinely doing interdisciplinary work with people from other disciplines, publish in peer-reviewed journals, have all of the stuff we've heard so far just invites to be rigorously engaged with people in other disciplines. And I love the point about having graduates, working with graduate students from other departments in your university as well as the faculty, and then building out relationships. And then I think having an open tent. I know with the knowledge commons thing, we start out with 3 of us, and now there's dozens of people using it, and it's sort of figuring out a way to have an open tent for people from other disciplines as well as law making it so that people can have reputational advantages, tenure decisions. It's not going to hurt tenure decision to write an article that's more descriptive and case study based, as opposed to the next best law review article that argues for a reform in doctrine.
Yeah, the other thing I'll say, I thought this was an intriguing model, and I'm curious to try it. I was talking to a former colleague at Stern, who said that they gathered together a group of people in diverse methodological approaches to work to talk about things, and then they publish a document with questions, the detailed questions that come out of it. Because a lot of times there are people out there with skills that are looking for things to ask about, and they don't know enough about how we might frame it with our legal knowledge infused into that. And so it's something you don't want to keep for yourself, but would be interesting to answer. It's important to get that out there as well, because there are people that have questions bank.
Okay, so, go ahead, Irene.
I think there is a very important role in this and collaborative research in defining by the center or by person's interest the type of project in terms of field, in terms of topic, and then within it build multiple either conferences, books, and corporate papers. The corporate papers are very useful, particularly when you ask for corporate papers in multiple disciplines. Trademarks, you want to have the marketing literature people, you want to have the brand expert, you want to have economists and support, and really build up that collaborative research that builds, usually the publisher now or open access. I think that really is that from there it trickles down the more. It is more fun because you work with a team, with smart people, and
All right, well, I would love to have this conversation for another few hours, but unfortunately we're out of time. I know people are going to be celebrating the holiday. If you're one of those, happy holidays, happy Passover, and otherwise people have to meet the rush on the greater New York highway system, which is the only way of getting to this campus, unfortunately, with any kind of convenience.
There's a train and a bus.
There's a train and a bus.
Before I knew you were sending cars, I had the train and a bus.
There is a train and a bus, and it can be done. Yes, no, it can be done. But in any event, not to close the matter, thank you all for coming. Thank you to Eva, to our IPLC fellows, Mike and Alicia. Where did Alicia go? Alicia. Thank you to Claire, who's sitting in the back there, who made sure everybody got here today. And we're adjourned. I'll see you all again.
Jeremy.